I must get comment from Crispin Perry just to gauge the sense from correctional services following this judgment that, of course, said that Minister Ronald Lamola was irrational in denying Janusz Walus parole back in March 2020 and must now release Janusz Walus, who killed Hani within 10 calendar days.
Yeah, well, we've noted the court's decision. We'll have to really look at it carefully to understand the basis for those conclusions, and then we'd have to apply it where we can. But yeah, that's the long and short of it. The decision has been made by the court, and we'll have to consider it and apply it.
The minister is accused of delaying this process intentionally, being biased, incompetent in the level of being the administrator, given that he does mention that Janusz Walus met everything, all the parole conditions, except, of course, for those two, which is the nature of the crime and the sentencing remarks made at the trial there.
On the contrary, the court was looking at the factors which the minister considered and the reason for remitting or not remitting the decision to the minister. And so he was applying case law as to some of the factors that you wouldn't remit a case to a minister for or an administrator for decision. So it wasn't a case of the minister being incompetent or delaying. Remember, it's the first time that the minister is looking at this decision, although historically the department has held this matter, as the court had noted, for 15 years. So it wasn't a decision, or it wasn't an impingement on the minister directly, but it was something to be said about how you go about deciding not to remit a decision to a minister. So in that regard, it would be unfair to say that the minister was accused of incompetence. On the contrary, they did state what the reasons were for the minister, and they did state, the minister stated his reasons quite clearly, but the court differs on two factors of those reasons, one being the nature and the seriousness of the crime, and the other being the sentence remarks as well.
And the other issue was that the minister wouldn't, of course, give, even in the responding affidavits, times on when Janusz Walus would be released, mentioning that those two factors would be a factor that would be still factors whenever parole needed to be considered. Why did the minister not give indication on when the possible parole could be given?
Because normally when the minister says that someone would be eligible for reconsideration, they would say that someone would be eligible for reconsideration, say, in a year's time, so that they have to undergo certain parole procedures and so on. But in this case, like the court has said, the nature and the seriousness of the crime would remain, but it's always going to be a factor. It is part of the factors when one does consider parole. So you wouldn't necessarily ignore the fact that someone is a murderer when giving them parole. You have to understand what impact this would have in society when you release an individual. You'd also take into consideration what the court says about this individual who has been incarcerated. So those are factors. They're not insignificant factors at all. And the minister had to take those into consideration amongst the list of other factors as well.
In past cases, the courts have always referred the matter back to the minister to consider it. But now we're seeing that the highest court in the land, the Constitutional Court, is ordering that within 10 days, Janusz Walus must be released. Does the ConCourt have the powers from your administrative point as a correctional services to give that order? Or is it something that the minister should be doing when we look at separations of power?
Well, the court has applied the ConCourt judgment in applying its analysis as to why it's made that decision. We will study the judgment and read it carefully and see if we are of the same view as well. But like the court did apply its rationale, it's not for us to necessarily second guess the second highest court or the highest court in the land in that regard. But like I've said, they highlighted the rationale for it. They highlighted the legal principles behind that decision. We will carefully consider those legal principles because we are obliged to, and we will then do what is necessary in that regard.
Okay. 10 days, you say? And perhaps maybe just Belan Pahadi from Newsroom Africa. And in 10 days, could we see perhaps even an application for one to have this particular decision maybe rescinded? Or perhaps you, as you said, you're still going to be looking at the paperwork from the judgment from Chief Justice Walus?
Yeah, we have to consider the legal principles at play and apply ourselves as well before we make a decision whether to appeal or not appeal. I can't say here whether there will be an appeal or there will not be an appeal. That's preemptive. We really have to study the judgment quite carefully for us to understand what is being said, what legal principles have been applied, and how they apply to our context. And then, therefore, we'll be able to know how to go about either applying the decision or considering whatever other legal options there are, as any other party would be eligible to do in matters of this nature. Of course, we do understand that it's the highest court in the land, That's a factor that we have to consider as well. But what's most important is that we have to really look at the judgment and understand the principles, because it's a very important judgment, of course, given where we come from as a country and the nature of the decision that has been taken. So we'll have to really apply ourselves, given the fact that it's the highest court in the land and it's reached this point.
The country in itself, back in 1993, towards that particular milestone of elections. Right now, almost 30 years in, what do you possibly feel that the South Africans would have as a reaction to this particular judgment? Do you think it is something that will go down well or not well with them, or they feel that injustice, as the SACP has said?
No, I can't speak for the whole of society. I wouldn't want to go and venture into speculative views about how this judgment would make people feel. But naturally, by nature, decisions of the court always make people feel differently about their decisions. Some people would look at it from a legal point of view. Some people will look at it from a political point of view. Some people will consider various factors. So it's not for me to say how society should feel and how they would feel about it. But naturally, decisions of the court do not please everybody. There's a saying, when you go to court, there's always going to be one winner. And naturally, that's what we're seeing in this instance. And that's what we'll continue to see in many other decisions of the court. Not everyone always wins, and you might not always be on the winning side.
And just lastly, have you spoken to Minister Ronald Lamola on the proceedings? I'm sure he was watching as well, but during the last hour of the judgment being given, what's he saying?
We will be consulting with the minister, with our senior counsels after having received the judgment, and we'll apply ourselves thereafter. So no, I've not spoken to him yet, but we will be in consultation with him soon.